I want to, he also said, you question, you don't recall. He again says, I don't recall having done that. Doesn't mean that I didn't. It just means that I don't recall. And that same page, about 3/4 of the way down, Travis Deane testifies, I don't remember a large portion of the evening. I also took part in the alcohol. The things that stand out in my mind don't pertain to them, meaning Kelly and Lindsay, in any way, shape, or form. Do you see that?
I see it.
So you think you were intoxicated during the time of your party? He answers, at some point during the course of it, absolutely. So,
At some point, but at what point was he that intoxicated?
well, I'll have Mr. Deane answer that question. But, so you agree with me, sir, that number one, for people that have been under the influence of alcohol can sometimes have foggy memories of what happened in the hours before they drank, correct?
Objection. Question.
He already answered it once. I'm just going to clarify his testimony.
Asked and answered?
Then you can
No,
respond, sir.
we've already been there.
We've already been there. Okay. Would you agree, sir, that in relation to these aspects of the transcript on page 8, where Travis Deane essentially tells you you don't know that the evasiveness that you claim existed there may have in part be explained by the fact that he was intoxicated that evening?
If that were the case, possibly.
And he never, nowhere in this portion of the transcript did he refuse to answer your question, did he?
No, he did not.
Okay. He didn't walk out of the room and ask for legal counsel, did he?
No, he did not.
He didn't confer with legal counsel before responding to the question, didn't he? Did he?
No.
And he just, as the minute you asked your question, he responded to it, didn't he?
Yes.
And he simply responded, I don't know. And that's what you call evasiveness.
Well, when you're talking circles, that's evasiveness.
How is I don't know a circle, sir?
It's not that he's saying I don't know. It's his responses to the questions.
His responses are I don't know.
Well, in addition to his other responses.
What other responses are you pointing
The
to?
one we were just talking to about that doesn't preclude the possibility that it may have happened.
Which means it could have happened, it could not have happened, I don't know. That's not a circle, sir. That's just, wouldn't you agree?
Okay,
That's not a
okay.
circle, that's just another way to say I don't know. Wouldn't you agree?
That's your opinion, yeah?
What do you think? Is that another way to say I don't know? To say it could have happened, it might not have, I don't know?
Well, if he doesn't know, he doesn't know. But then he puts the little spin on it there, so.
Spin? He
Yeah.
says it
I
could have
don't recall
happened,
again.
it could not have happened. That's spin?
Well, yes. He puts,
I'll leave that for the board members to consider.
okay.
Now, what other part of this transcript did you feel that Mr. Deane was being invasive with you in? I believe
Once
that.
again, when we're talking about page 14,
Where it says, did you recall her with a cup in her hand?
yes.
And he responds, I don't recall seeing her with a cup in her hand, but I'm not going to deny that it didn't deny that it happened either.
Okay.
That's evasive?
No, that's the
Okay.
beginning of the line of questioning.
All right. What specifically is evasive, sir?
I don't, let's see. So you don't, where I said, okay, you don't recall going to the beer keg in the garage, pouring the beer from 2 taps, and then handing it to her saying, here, what do you think of this? His response was, I don't recall doing that. They both said I did, so I'm not going to say I didn't do it, but I don't remember having done that.
That's evasive. He says, let's break it down. I don't recall doing that. They say I did. So I'm not going to say I didn't. That's evasive?
Well, not that one in particular.
Oh, okay. What is evasive then?
May just object to this line of questioning, only from the perspective that the violations he was charged with, he wasn't charged with he wasn't charged with being untruthful. In any of the 5 things he was charged with, he wasn't charged with being untruthful. The sheriff's termination letter indicates that based on the investigation, they felt he was less than forthright, but he wasn't charged with being untruthful. So while Sergeant Tatum can go through the entire interview and tell you the things he thought he was being evasive about, it's not necessarily relevant to whether he committed the offenses he was charged with.
The sheriff, in his final termination letter, which I'll be happy to show the board members.
They have it.
They have it. Went on for a paragraph right before he made the final termination decision that Mr. Deane was evasive and lacked forthrightness in his IA interview. It's roughly this second page, second paragraph, or third paragraph, I think, of the termination letter. I'm only trying to get at the truth of whether or not he really was evasive, and I'm entitled to do that, I believe. If the sheriff is going to accuse my client of a lack of forthrightness, due process and just common decency gives us the ability to ferret out whether or not that allegation is true.
The sheriff didn't rely on that as a violation of policy as a reason for terminating him. It was part of the letter.
Why is it in the letter?
Why not? The sheriff can write the letter any way he wants to write the letter, but he wasn't charged with veracity or lack of veracity, so Sergeant Tatum's opinion or the sheriff's opinion as to whether or not he was forthright and honest, the board can sit and read the investigation or the interview if they want themselves and decide for themselves if he was less than forthright. But at the end of the day, when you're considering what he violated, whether he violated these 5 directives, veracity isn't one of them.
Well, it's funny. You went on in your opening statement about how my client lacked forthrightness. It certainly seems to be relevant to these proceedings. If not, you wouldn't have used that in your opening statement. Neither was the witness be asked questions by you about my client's alleged lack of forthrightness. So obviously it's an issue. An issue I'm entitled to get at and get to the truth of.
Mr. Butch, I'd appreciate it if you would not address me that way in the hearing. The board can make a decision about the objections.
And I apologize. I tend to get a little animated when my client's rights are being trampled on. But I do respectfully request that since this issue has been brought to the fore by Ms. Jones, been brought to the fore by the witness, and certainly been brought to the fore by the sheriff in his termination letter, that I asked that I be able to get up to the truth of whether or not he did engage in any lack of candor or lack of forthrightness or evasiveness in his IA interview.
And I think Sergeant Tatum has addressed that.
Well, in fairness, he said that he believed he was invasive in aspects of his transcript. I don't know that he's finished with his review of that transcript. It may be there are other areas that need to be dealt with. I believe that was a question I asked before I received the objection. If there's nothing else, I'll move on.
I think we can make that determination by reading the report ourselves as to whether we think it was forthright or not. That's a determination that we need to make when we read how his answers were responded to. Badgering the witness to see if he has had too much to drink or whether he's trying to point out different things, that's his opinion, and we have to make our opinion also of that by reading the report like you're trying to go over.
Well, I believe the point of this hearing, with all due respect, is to give me an opportunity to question the veracity of the allegations made against my client. If that's not what I'm here for, then I shouldn't be billing the Teamsters what I'm billing. If I'm not going to be allowed to ask questions of witnesses which are terribly relevant, as demonstrated by her opening, his own testimony, and the sheriff's letter, then there are due process issues here that abound.
Well, I think this board wants to hear all the evidence, and then we have the responsibility of ruling on that evidence.
Well, that's what I'm trying to do, sir. But if you're not going to let me question the witness on this point any longer, say so, and I will have no choice but to move on.
If you can do
With an
it
exception,
in
of course.
one question, one simple question, and not go on and on and on with 10 questions about it, I'll allow it. 2 questions?
Ma'am, let's just see where this goes.
Okay.
When I studied in law school, I never read anything about a 2-question rule, but I'll do my best to see what I can do under the circumstances. Now, are there any other aspects of this transcript, sir, dated, dated March 12th, 2012? that you felt suggested that Mr. Deane was being evasive in your questioning of him?
Without going through and reading the whole transcript again,
Okay, and I'll leave it at that. So your answer is no, without going through the rest of the transcript?
correct.
All right, very well. Now, I'm gonna hopefully pick up a little speed here. All right. Your investigation revealed that at that November 5th, 2011 party, that Kelly Capps and Lindsay Haynes obtained alcohol and consumed it, correct?
Correct.
All right. Now, specifically regarding Lindsay Haynes, what did your investigation reveal was the amount of alcohol that Lindsay Haynes consumed?
She tried the beer that Deputy Deane had handed to Kelly Capps, who handed it to her, so she had a sip of the beer, and then she had half of a Jello shot.
Okay. So a sip of the beer and half a Jello shot for Lindsay Haynes?
Yes.
Okay. Is there any suggestion that at that party, Lindsay Haynes became intoxicated by the amount of alcohol she consumed there?
No.
Is there any evidence that she was involved in an accident on the way home because of any possible effects of the alcohol she consumed there?
No.
Is there any excuse me? Is there any evidence that she had anything other than a good time at the party?
I don't recall asking her that specifically.
Was there any evidence that she was battered during this party?
There was no allegation of that, no.
Very well. Was there any allegation that she was called names or that she was ridiculed during this party?
No.
Okay. Let's talk about Kelly Capps. Now, Kelly Capps, at the time of the party, was 18, correct?
Correct.
She was invited by Mr. Deane.
Correct.
Okay. Well, I need to jump back to Lindsay Haynes just for a second, and I'll leave her alone. Was there any evidence that Lindsay Haynes was invited to the party by Deputy Deane, Mr. Deane?
No.
Okay. So she was a guest. She was invited by either Kelly Capps or Wade Hunter, to your knowledge?
Yes.
Okay. Is there any evidence that Mr. Deane knew of Miss Haynes' age when she arrived at the party?
That I don't know.
Okay. So at the time that she arrived at the party, Miss Haynes was 17 years old?
Yes, she was.
Okay. But not an invited guest to Mr. Deane?
No.
All right. Now, moving back to Kelly Capps. Now, how much alcohol does your investigation reveal